I ask the court to find that it's the clear legislative intent that you cannot waive your LAD rights, no matter what the clause says, no matter what the policy manual says, no matter what the application of employment says. And the legislature's been clear on this. They passed NJSA 10:5-12D, which says employers cannot coerce, intimidate, threaten, or interfere with any of the rights under the LAD. The legislature also passed 2A:14-2, which says there is a 2-year statute of limitations. This court interpreted that statute as applicable to the LAD 22 years ago. The LAD has been amended numerous times since then, and the legislature was aware of this court's ruling that 2A:14-2 applies. Clearly, nothing a defendant writes or says should be allowed if it interferes with any citizen's right to redress discrimination under the LAD. Justice Patterson asked, why is this different than two businesses? It's different than two businesses because our legislature has clearly told us it's different. Because there's a public interest here. It's not private disputes. It's not two private entities entering into a shortened statute of limitations.
Well, doesn't it also have a substantive impact on the remedy as well, Ms. Smith? Suppose this had been an action that dealt with disparate pay. The limitation, a shortened SOL, would reduce the amount of damages that could be available to the wronged employee. Is that not correct?
By 75%.
Now let me ask you another question.
Yes.
Suppose this agreement was allowed to stand. It would be viewed as a substantive limitation on the remedy available under the LAD. Would it limit the Attorney General's ability through the DCR to seek redress against the wrongdoing employer on behalf of an employee if the employee had signed this agreement?
Absolutely, and the DCR is a very important aspect of the legislative scheme. Our legislature specifically allowed every victim to go to the DCR without a lawyer, no costs, and have an investigation.
So it has a very real impact on
very real impact.
The amount, the extent of remedy available under the LAD.
It definitely limits remedies. I know that in the amicus, the defendant said contrary, but clearly does. If it's 6 months and you get into court in January of 2016, you're not going back to January of 2014, which you would in court or the DCR.
Right.
So it not only limits remedies, it limits your ability to go to the DCR. Justice Albin asked, what's the average time to file an LAD claim? My firm has been in practice for 35 years. This is all that we do. We filed thousands and thousands of LAD cases. I don't think one of them has been filed in less than a year. And that's because it takes time for all the reasons listed of the distress and upset of being terminated or being subjected to harassment. We always try to negotiate, to try not to run into court. And that takes a lot of time. Since this court's decision in Aguas, now we have to give the employer an opportunity to investigate. Rarely does an investigation take place in a matter of weeks or even months. And many times it's important to go to the Division on Civil Rights to get some information because we have an obligation to bring meritorious claims. Often they're on a contingency. We have a business interest to bring meritorious claims, and we have an obligation to our clients to bring meritorious claims.
Ms. Smith, if we were to affirm the Appellate Division's analysis in this matter, would there be anything in the way, anything that would prevent another contract coming down the pike that would eliminate the discovery rule from statutes of limitations?
But the words of this one says from the date. So this actual contract seems to eliminate the discovery rule, the concept of continuing violations, and the concept of equitable tolling. Yes, why not waive child labor laws? Why not waive wage and hour laws?
Now, much of the argument that we've seen from the parties on representing the employer deal with the fact that the LAD doesn't have within itself a 2-year limitation period or language that says expressly that you may not waive it. Is that the correct analysis under an unconscionability prism? Because that essentially equates the fourth prong of Rudber with essentially a preemption analysis, as opposed to let's look at the public interests that are involved and see whether or not they're thwarted. Which do you think is the more correct analysis?
I definitely think it is not a correct analysis to say the legislature didn't say you can't waive the statute, or the legislature doesn't know that for the past 22 years the statute has been a statute it passed, 2A:14-2. The legislature has amended the LAD many times, and the legislature has spoken repeatedly. The 1991 amendment, which was read to your honors, talked about the public interest in righting these wrongs and the terrible, grievous harm done to victims of discrimination and the public. Many of the amendments since then every amendment actually, has expanded the rights under the LAD. None have contracted. The legislature, I don't think, can be clearer. It does not want these rights abridged. That's why it enacted 10:5-12D, saying you can't interfere with these rights. So knowing that we have a 2-year statute of limitations, the legislature did not have to act, because it has already said an employer cannot interfere with these rights, including the right to go to the DCR. The DCR, in my 35 years of practice, has never, ever made a decision in 6 months, never completed an investigation in 6 months. You're literally taking away a right carefully thought out. And I haven't even gotten to the Attorney General provision in the statute.
What's your experience in terms of the length of time in DCR?
The DCR often does not complete it within 2 years, but it depends. Actually, the DCR, in my 35 years of experience, has had prosecutions and investigations that were more vigorous and sometimes than others. But recently, we have had a DCR that has taken a real interest and brought some very important cases. I think that they probably filed them right before the 2-year statute of limitations. It's a complicated area of the law. You don't want to file one of these cases lightly. They're hotly litigated. They're expensive. They're fought hard. And the DCR and private attorneys don't want to just file them quickly. We want to take our time. We don't want to bring a client through 2-3 years of litigation and appeals for a case that's not valid and doesn't have a lot of merit.
I stopped you before you were going to get to the Attorney General.
I'm sorry, the Attorney General. Also, the legislature gave the Attorney General an opportunity to take action. I don't believe ever that the Attorney General has taken action within 6 months. They're literally taking away rights granted to the government by limiting the statute of limitations to 6 months. I don't think a private employer, the very people who the legislature wanted to regulate after finding that discrimination in employment is a problem. 70 years ago, we passed the LAD in 1 day. It was signed into law in 1 day. It was passed unanimously by our legislature. I'm very proud of that. I'm proud of this court and how we have been in the forefront in the country in fighting discrimination and eradicating it as a cancer. We haven't succeeded, but we are in the leadership in trying, at least. This 6-month statute of limitations forced upon anybody who wants to eat or put food on their children's table is very wrong and contrary to everything we stand for.
Thank you, Ms. Smith.
Thank you.
Dean Chen.